Hello, it's HB Dlamini again with Module 7 of Public Law N6. The reference would be Public Law N6 book by A. Kruger, and what we require from you is also a book to be next to you so that when we refer to it, you'll be able to see what we really want. So what our topic today is in Module 7, the civil liability of the state. So civil liability of the state, it's according to private law. So the law of liability of the state provides us with answers as to whether the state can be held liable for a delicte or unlawful act against the citizen. The answer is yes. In terms of the Act, the State Liability Act 20 of 1957 and the Amendment Act 14 of 2011. So, if you want to sue the state, you can in terms of this act. So I want to give you an example as to how these things do happen. My example is this one. Sipo is walking on the street and he gets shot and injured. He's injured by a policeman who is chasing a suspect. The question is, since the police is the state official on duty working for the state, would Sipo be able to sue the state, or is the state liable? The answer is yes. The Act, that is the State Liability Act, provides articles and the conditions with regard to the suing of the state. Any claim against the state, if the claim is against an official of the state and there are grounds for the claim, it should be tried in the court of law. The claim can arise from any contract lawfully entered into on behalf of the state that was broken or breached or infringed, or any unlawful act or wrongdoing by an official of the state when acting in his or her official capacity. For example, in our example, this one, it fits. Excuse me. A lawsuit on the basis of the above must be instituted against the executive authority of the state institution. For example, the minister of the relevant department. In our example, it's going to be the Minister of Police. The claim against the department must be for an amount and cannot be against a defendant or government property. This means if you make a claim against the state, it can only be an amount. You cannot claim the state and say you want the state to pay you in kind, or you want the state to pay you by giving you a land. That cannot happen. The claim will then be settled or not, depending on the verdict of the court. If the claim is awarded by the court, it must be paid within 30 days of the date of the order or in the period agreed upon by the parties. There are conditions regarding the institution of the claim. These conditions are from the very same act, right? The conditions are as follows. The state can only be held liable regarding the action or neglect of an official of the state or department. The official must have been acting as an official of the department. In our example, you remember that the delict which took place against Sipho, it was the policeman who was shooting and Sipho got injured, right? So the policeman is an official of the department. The official must have committed an unlawful act within the scope of his or her official powers, right? Well, this policeman was wearing uniform, for example, as he was chasing the suspect and unfortunately shot Sipho. So he was acting within the scope of his duties. The applicant or his or her legal representative must, within 7 days, indicate to start the proceedings against the relevant executive authority and must serve a copy of the summons to the state attorney. You'll remember about the state attorney. State attorney in your book, it's page 41, where we spoke about the main functions of the state attorney. So the matter must be taken. One copy of the summons must be served to the state attorney, who will take up the matter of the official. So these things do happen. It's not only the police. You can also make an example with the hospital, the nurses, the doctors. They can also commit delicts, and you may claim in terms of this act, the State Liability Act. Thank you so much. Thank you so much. And this is the end of Module 7. And we'll be taking Module 8 from tomorrow. I wish you luck in your studies. Thank you. Bye.